So let's go ahead and get started with the largest section of the exam. Practice of real estate and disclosures. This includes specialty areas on the California exam. Again, 25% of the licensing exam will be related to these topics. Let's start with trust account management. Trust funds, also known as escrow funds, are money or items of value belonging to others that licensees receive and manage for specific purposes in real estate transactions. Real estate escrow accounts hold money on behalf of others, including earnest money deposits, rental security deposits, and any other funds being held in trust. Real estate licensees must deposit trust funds into a brokerage trust fund bank account or with a neutral escrow account managed by an escrow company. The funds must be deposited within the time frame specified in the purchase agreement, which is usually within 3 days of offer acceptance. The account in which trust funds are deposited must be separate from the broker's general operating account. A nominal amount of brokerage funds may be deposited in the trust account in order to cover banking fees, but that's it. Mishandled trust funds can result in the suspension or even the revocation of a licensee's real estate license. 2 huge no-nos: commingling and conversion are 2 primary ways licensees can go wrong. Commingling. When trust, aka escrow funds, are mixed with personal or brokerage firm funds. Your money should not flirt with the brokerage money. Conversion is using trust funds for anything other than their intended purpose. If I convert your earnest money deposit to help me cover my sushi lunch, that is possibly going to get my license suspended or even revoked. Trust funds must be handled in a specific manner according to the established legal procedures and standards. These are established in California by California law and the California Real Estate Commissioner. Trust accounts are set up to separate trust funds from non-trust funds. Non-trust funds, again, can be deposited in this account, but only to cover sufficient banking fees. All other deposits must be trust funds. Trust fund accounts are insured for up to $250,000 by the FDIC. That's $250,000 by the FDIC. Trust accounts provide additional security for trust funds in case of circumstances such as the broker's death or the account being frozen, or if the broker or licensee is caught in litigation. Trust funds in a trust account belong to the party who submitted them until they're dispersed. Mishandled trust funds, again, result in either suspension or revocation of a licensee's real estate license. Moving right along into fair housing laws. Fair housing laws are designed to protect citizens from discrimination. States cannot make laws that remove rights that federal laws grant to citizens, though they can pass more restrictive laws or add additional classes to those protected by federal law. Civil rights and fair housing laws have evolved over time. Significant court cases that you should know involving civil rights start all the way back in 1866. The Civil Rights Act of 1866 prohibits discrimination based on race or color. There are no exemptions under this law. It is never legal to discriminate on the basis of race or color. This act protects the rights of U.S. citizens to buy, sell, convey, inherit, and possess property. The act, however, did fail to have an immediate impact on discrimination because no agency was assigned to enforce it. In the 1890s, Plessy versus Ferguson set a fair housing precedence, which led to what would be known as the separate but equal doctrine. In Buchanan versus Warley, 1915, a city ordinance prohibiting black people from living on a block where existing residents were white banned William Warley, an African American, from moving to the block where he wanted to live in Louisville, Kentucky. So he backed out of the sale. The case eventually ended up in the U.S. Supreme Court, which determined that the Louisville Ordinance violated the Civil Rights Act of 1866 by denying to the colored race the enjoyment of all civil rights. In the 1950s, Brown versus the Board of Education took place, which is a famous turning point for civil rights law in the United States. It eliminated the idea that separate but equal was fair and just under the law. In Jones versus Alfred H. Mayer Co., the court determined that even private homeowners could not discriminate in housing sales and rentals. The Fair Housing Act was passed as Title VIII of the Civil Rights Act of 1968. This act prohibits housing discrimination based on race, color, national origin, and religion. The Housing and Community Development Act, which passed in the 1970s, added sex to the list of protected classes. This gave protection to women, who are often subject to sexual harassment from landlords and sellers when attempting to obtain housing. The Fair Housing Amendments Act of 1988 extended fair housing protections to cover familial status and disability. It also provided remedies to victims of housing discrimination. It required that owners make reasonable accommodations to property rules, policies, and practices in order to provide persons with disabilities appropriate access. Federal laws outline 7 protected classes: race, color, religion, sex, disability, familial status, and national origin. Some courts have upheld that discrimination based on sexual identity is protected under the prohibition of discrimination based on sex. Race and color are 2 protected classes, but they are different in meaning. Race has to do with ancestry, color has to do with the color of one's skin. National origin is a protected class that has to do with a person's geographic origins. National origin can be specific, for example, people from Mexico, or more general, for example, people from the Middle East. Familial status refers to anyone who has a child under 18 living with them, including pregnant women and those in the process of adopting. The following activities are considered covered transactions related to anti-discrimination laws: selling or renting housing or residential lots, providing real estate brokerage services, performing appraisals or providing financing, advertising housing for sale or rent. It's illegal to perform any of the following acts if the action is based on discriminatory factors and involves a protected class: refusing to sell or rent a house, refusing to show an available house or a unit to a prospective buyer or tenant, offer different terms, conditions, or privileges when selling or renting a house, indicate a preference or limitation when advertising a home for sale or rent, coerce, threaten, intimidate, or interfere with a person's housing rights. There are some exemptions or exceptions to federal fair housing laws. The Housing for Older Persons Act of 1955 provided exemptions for housing specifically designed for seniors. The exception allows those who live in senior developments in which at least 80% of the units are occupied by at least one person who is 55 or older to choose residence on the basis of age. They may not discriminate on the basis of any other protected class. Owner-occupied buildings with no more than 4 units may be exempt. This is commonly known as the Mrs. Murphy exemption. This exemption is disallowed if the owner uses discriminatory advertising or if a licensee becomes involved in the transaction in any way. Roommates who share a rental unit may indicate a gender preference when selecting a roommate, including in advertisements, as long as the situation involves shared common areas such as the bathroom and kitchen. Single-family housing that's sold or rented without a broker's assistance, if the owner doesn't own more than 3 properties at one time, is exempt. No real estate licensee may be involved, and no discriminatory advertising is permitted. Housing that's operated by religious organizations or private clubs that limit occupancy to members are exempt, provided that membership rules do not discriminate. Discrimination based on race is never permitted under any circumstances. The Office of Fair Housing and Equal Opportunity, OFHEO, which is part of the U.S. Department of Housing and Urban Development, HUD, enforces federal fair housing laws. Aggrieved parties, including licensees, can file fair housing complaints through the OFHEO for as long as 1 year following the time the alleged discrimination occurred. Licensees may not file on behalf of any other aggrieved party. A fair housing specialist will review the complaint, determine if a violation exists, and if so, assist the victim in filing an official complaint. Suspected fair housing violations may be investigated by a civil rights organization using a paired testing system to determine if discrimination has taken place. If found guilty of federal fair housing violations, licensees may face license suspension or revocation, lawsuits, and payment of compensatory damages. Title II of the Americans with Disabilities Act, ADA, of 1990 prohibits protected class-based discrimination in the delivery of commercial and public programs, services, and activities. The law is administered and enforced by HUD. Disability or handicap is a physical or mental impairment that substantially limits one or more of a person's major life activities. The ADA requires business owners to make a reasonable effort to resolve usage barriers for people with disabilities. For example, lifts or ramps should be in place for wheelchair accessibility. Housing providers may inquire as to the nature of a non-apparent disability if an applicant requests ADA-related accommodations or services. A service animal is not a pet. The ADA requires a landlord to make reasonable accommodations for service animals and for all disabled persons, not only the visually impaired who use a service animal. The Equal Credit Opportunity Act, ECOA, of 1974 requires lenders to give consumers equal access to credit. The act prohibits discrimination based on race, color, religion, national origin, sex, marital status, or age with respect to granting credit, and requires lenders to respond to all loan applications within 30 days, giving reasons for any application rejections. Redlining. Redlining is an illegal discriminatory practice by lenders or insurance companies that refuse to lend or that limit business within specific geographic areas based on the demographics of the area rather than on the creditworthiness of the specific borrower. Figuratively drawing a red line around an area to indicate unwillingness to lend mortgage funds for or insure homes in that area. In another twist, the practice of charging non-white borrowers higher fees or interest rates may be referred to as reverse redlining. Blockbusting. Blockbusting is also known as panic selling, and it is the act of inducing property sales by threatening that the changing demographics or the entry of a minority resident will decrease home values. Licensees who engage in this behavior for their own profit are guilty of violating fair housing laws. Steering. Steering is the act of guiding prospective buyers or tenants away from a location based on their membership in a protected class. Licensees who engage in this practice are guilty of a fair housing violation. Buyers and tenants are free to select properties based on demographics, as long as licensees don't use demographics as a basis for showing properties. California's Fair Employment and Housing Act, FEHA, FEHA, extends protections to several classes in addition to the 7 federally protected classes. Protected classes under California housing law are race, color, religion, national origin, ancestry, disability, mental and physical, sex, gender, gender identity, gender expression, sexual orientation, source of income, marital status, familial status, genetic information, age. In addition, citizenship, primary language, and immigration status are protected under the Unruh Civil Rights Act, which applies to housing accommodations. Ranging from advertising and selection processes to land use practices and restrictive covenants. FEHA doesn't include owner-occupied single-family homes, renting a portion of the house to one person, as long as the owner doesn't post discriminatory advertising. When a rental includes shared living space, advertisements may specify that the rental is available only to renters of one sex. FEHA prohibits discrimination and harassment in a variety of housing practices. The Unruh Civil Rights Act protects specific classifications of people from discrimination by all business establishments, which includes most housing accommodations. While the Unruh Civil Rights Act specifically lists sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, or sexual orientation as protected classes, the California Supreme Court has held that protections under the Unruh Act are not necessarily restricted to these characteristics. The Act is meant to cover all arbitrary and intentional discrimination by a business establishment committed on the basis of any personal characteristics similar to those of protected classes. Housing complaints in California may be resolved through the Department of Fair Employment and Housing's formal complaint process. This is the DFEH's complaint process. The formal process begins with filing a complaint, then proceeds to an investigation. If a violation is discovered, the process continues until resolution is found, which may be through litigation by the DFEH. The Fair Lending Notice discloses the 2 types of discrimination that are prohibited by the Housing Financial Discrimination Act, also known as the Holden Act. The Act prohibits discrimination by lenders based on protected class of the consumer or the characteristics of a property's location, aka redlining. The truth in advertising. The Federal Trade Commission FTC Act protects consumers from unfair and deceptive advertising. The Act works to ensure that advertising is truthful, non-deceptive, fair, and evidence-based. An unfair ad is one that causes or is likely to cause substantial consumer harm, which is not outweighed by benefits to the consumer. A deceptive ad is one that contains statements or omits material information and is likely to mislead consumers who are acting reasonably. The FTC determines penalties based on the violation's severity. Penalties range from a cease and desist order, which becomes effective immediately, to corrective advertising, civil penalties, consumer and other monetary remedies, and informational remedies such as consumer notifications and disclosures. The Do Not Call Implementation Act of 2003 makes phone solicitation to numbers on the Do Not Call registry illegal, unless a prior business relationship or permission exists. The CAN-SPAM Act of 2003 protects consumers against unwanted email solicitations. Under the Junk Fax Prevention Act of 2005, go ahead and say that 5 times fast. Junk Fax Prevention Act, Junk Fax Prevention Act, Junk Fax Prevention Act of 2005. It's illegal to send an unsolicited commercial message via fax unless the sender has permission from the recipient or an established business relationship with the recipient. Licensees must include their licensed name, license identification number, and broker's responsible identity on all first point of contact advertising materials. First point of contact materials that fall under the California Department of Real Estate advertising requirements include business cards, brochures, advertisements, for sale signs, directional signs, and other items. Inducing or attempting to induce panic selling and advertisements is prohibited. Internet advertising must also include the required identifying information. It needs to appear on each page of a website on which licensee advertisement or information appears, and in with any electronic communication. Sources of information licensees can use for advertising rules include the DRE reference book and the broker's Policies and Procedures Manual, also known as the PPM. Misrepresentation. Misrepresentation is a false statement of a material fact. It can be intentional, unintentional, or made through lack of proper care. Negligent misrepresentation. An example of negligent misrepresentation is when a licensee makes a misstatement that the licensee should have known was false. Intentional misrepresentation includes remaining silent and misstating facts. Misrepresentation becomes fraud when it's intentional. Omission of a material fact is considered intentional misrepresentation. Puffing or puffery is unfortunately not this cute creature. It's making an exaggerated statement that is generally understood not to be statement of fact. The Lanham Act, spelled Lanham, Lanham, is a federal act that gives individuals and businesses the right to sue any competitor for making deceptive claims in its ads. Antitrust involves businesses that conspire to restrict competition or trade, resulting in diminished choices or higher prices, or both for the consumer. The Sherman Antitrust Act of 1890, the Clayton Act of 1914, and the Federal Trade Commission Act of 1914 are all federal antitrust laws that protect consumers from tie-in arrangements, group boycotting, price fixing, and market allocation. The Sherman Act's primary purpose is to prevent monopolies that could cause a restraint of trade. The Clayton Act supports the Sherman Act by prohibiting mergers that would result in a monopoly. The Federal Trade Commission, created by the Federal Trade Commission Act, investigates antitrust violations and penalizes violators. Price fixing involves an agreement or collusion between competing brokers to fix contract terms, services, or products at a specific price or level, such as by suggesting there's a standard fee for brokerage compensation. For price fixing to occur, there must have been an agreement between competitors on pricing. Listing agreements in California have specific language informing the seller that commissions and fees are not fixed by law and are negotiable. Market allocation involves an agreement between brokers to divide up the market and then refrain from competing for business. Tie-in arrangements include providing a service dependent on the customer obtaining or not obtaining another service from a specific provider. Group boycotting is an agreement between two or more parties who conspire to not do business with a particular person or company. Basing your decision to do business with a vendor on your own experience or knowledge of the vendor's quality is fine, but agreeing among competitors to not use a specific vendor is illegal group boycotting. A per se antitrust violation is one in which the competing firms agree to violate antitrust laws. A per se violation means the authorities don't need to make any additional inquiries about the violation to impose penalties. The fact that collusion existed is enough. Penalties for antitrust violations may be as much as $1 million and 10 years in prison. For corporations, penalties may be as much as $100 million. Under certain circumstances, penalties may be increased to a fine equaling twice the perpetrator's gain or the victim's loss. Brokerage firms found guilty of violations may be subject to court-ordered supervision for up to 10 years. The Cartwright Act. This is California's antitrust law. It establishes specific actions as being antitrust violations and also permits private parties to pursue litigation against those who have committed antitrust violations. Record-keeping requirements. The DRE has the authority to conduct routine audits of brokers, brokerages, trust accounts, and other transaction records. Section 10148 of the California Business and Professions Code requires that brokers retain records pertaining to real estate transactions for 3 years. This includes listing agreements, deposit receipts, canceled checks, and other documents related to real estate activities that require a license. Licensees must give to signing properties a copy of any agreement a licensee prepares. That includes listing agreements, purchase agreements, property management agreements, contract addenda, and receipts for deposit. Deficiencies in trust fund handling procedures discovered during the course of an audit may result in disciplinary action for the broker and responsible licensees. Brokers who keep a trust account may maintain records using a columnar, paper-based system or a computerized accounting system. The chosen method of record keeping must be in line with generally accepted accounting principles. Record keeping for trust fund bank accounts must use, at minimum, a journal, a cash ledger, and a beneficiary ledger. What the heck are those? The trust account journal is a chronological record of all activity in the trust account. A separate beneficiary ledger must be maintained for each beneficiary of trust funds held in the trust account. Each beneficiary ledger must show the beneficiary name, property address, transaction dates, check number amounts, ending balances, reference numbers for deposits or receipts, and any other pertinent information for each transaction. A separate cash ledger is used to record deposits from and disbursements to the broker. Trust fund bank account records should be reconciled monthly. The purpose of reconciliation is to balance the trust account and ensure that all trust funds have been properly recorded in the journals and ledgers. Moving right along to agency supervision. Brokers must supervise the business and license-related activities of the brokerage as a whole and of each associated licensee and employee. California regulations require brokers to oversee the following activities: transactions requiring a real estate license, contracts, agreements, and any document that affects the rights or obligations of a party to the transaction, maintenance of transaction-related records and documents, trust fund handling, advertising for real estate services, compliance with federal and state laws prohibiting discrimination, reports for associated licensee activities requiring a license. Brokerage firms should create and implement a comprehensive PPM to help prevent violations. A PPM that covers best practices and guidelines and standards by which firm members perform their respective functions can help a broker prove supervision requirements are met, as well as avoid vicarious liability risk. If a lawsuit or disciplinary action is brought against one of the firm's associated licensees or employees, the firm's broker may be held liable for the misconduct through the concept of vicarious liability, which refers to a situation in which one party is held responsible for another party's actions or omissions. Most real estate licensees are independent contractors based on IRS rules. In order to maintain the independent contractor status of these licensees, brokers must provide supervision at the level required by the Real Estate Commission, but may not require independent contractors to work set hours, work at a specific location, or attend staff or training meetings. Independent contractors are paid based on sales, not on the time they spend at the job. Thanks so much, and talk with you all soon.